Good morning, Honorable Vice Chancellor of Pondicherry University and the Head Department of Social Work and Dr. S. Vijayan, the guest speaker today. Dear students, as you all know that today we have the awareness campaign on the criminal laws, which is guided by the Ministry of Home Affairs and the Higher Education, Government of India. As per the guidelines, today we are organizing this program for the NSS volunteers, NCC and the social work students. Before getting to the program, I invite Ms. Harini for the Master of Ceremony.
A very pleasant good morning to everyone gathered here. Today, we dive into a subject of immense significance and evolving nature. Criminal law in India is not just about rules and regulations. It's a living entity that reflects our society's values, challenges, and aspirations. As we navigate through an era of rapid change and unprecedented challenges, understanding these new trends is more crucial than ever. Welcome you all to the awareness session on criminal laws, which is jointly organized by National Service Scheme and National Cadet Corps, Pondicherry University, under the aegis of Ministry of Home Affairs, Government of India, in collaboration with the Department of Social Work. Before getting into the program, I request you all to kindly switch your mobile phones into silent mode to avoid any disruptions. The Indian legal landscape stands at the transition of significant change with the enactment of 3 new criminal laws: Bharatiya Nagarik Suraksha Sanhita 2023, Bharatiya Nyaya Sanhita 2023, and Bharatiya Sakshya Adhiniyam 2023 that repeal the British era Code of Criminal Procedure of 1973, the Indian Penal Code of 1860, and the Indian Evidence Act of 1872, respectively. When the Indian Penal Code was enforced on 1st January 1862, almost 1.5 years after its enactment, no one would have dreamt of any kind of cybercrime. Justice B.R. Gawai of the Supreme Court rightly said that law is not static but dynamic. It changes with time because society changes with time. In the past century, industrial, financial, and commercial growth has shown new heights. Likewise, crimes have also taken new shapes and forms which the old laws no longer can keep pace with. Consequently, it seems that these new criminal laws are the need of the hour, and it is important to have a basic understanding of the possible effects of these laws. I extend my warm welcome to all the faculty members, students, NSS volunteers, NCC cadets, and each and everyone present here. To begin our event, we have someone very special who will set the tone and officially welcome us all. His leadership and dedication has continually inspired us to reach new heights. It is my honor to invite Professor K. Anbu, Head, Department of Social Work, Pondicherry University, to deliver the welcome address.
Honorable Vice Chancellor of our University, Professor K. Taranikarsu sir, esteemed special guest and resource speaker of today's awareness campaign, Dr. S. Vijayan, other dignitaries, research scholars, MSW students, NSS volunteers and NCC cadets, dear faculty colleagues from other departments, invitees and guests, very good morning to all of you. I deem it a privilege and honor to welcome you all to this very important awareness campaign on 3 new criminal laws organized jointly by the Department of Social Work, NSS and NCC units of our university. Ms. Harini has already set the tone for the awareness by giving you the important introduction about the 3 laws. We know that these 3 new laws on Indian criminal justice system passed in Parliament last year and going to be in effect very shortly from July 1st onwards, which is aiming at revamping and replacing the already existing age-old colonial laws. We all know that we have three colonial laws. So to replace these three laws, the government has considered in implementing these three criminal laws through a victim-centered approach, we can say that way, victim-centered approach, and also giving importance to increasing focus on national security. So which makes these three laws very special and also very important in this present context. I take this opportunity to express our sincere thanks to the nodal officer, Dr. Gurmeet Kaur ma'am, for considering to organize this program, especially for the NSS volunteers, NCC cadets, and also our MSW students who are going to benefit very much, because we know that law plays an important role in social work practice. Many of the acts relating to children, women, persons with disabilities, elderly, and many other vulnerable sections of the society have profound effect on social work practice. The understanding of the provisions, especially of these three criminal laws, will provide that direction and also the power to the social work practitioners and volunteers of NSS and NCC to have a fair and effective service to the people. That's why this awareness campaign become very, very important. So we are extremely happy to have our Honorable Vice Chancellor, sir, who is the source of motivation for all of us in the university, who has kindly consented to preside over this function and to deliver the presidential address in spite of the hectic schedules, or heavy busy work schedules. Sir has found time to be with us today. Thank you so much, sir, and on behalf of all the organizers, I extend a warm welcome to you, sir. I extend a warm welcome to our esteemed special guest today, and he is also the resource speaker for this session, Dr. S. Vijayan, who is a faculty member in the neighboring institution, Dr. Ambedkar Law College, Pondicherry, for kindly accepting our invitation to deliver the awareness lecture for all our students and volunteers. Once again, on behalf of all the organizers, I extend a warm welcome to you, sir. I take this opportunity to welcome the nodal officer. So there are three few pillars behind organizing this program. Dr. Gurmeet Kaur ma'am, who is the nodal officer, and NSS coordinator, Dr. Satish Kumar, who is also the faculty colleague of our department, and Dr. Humayun, who is the NCC officer, and NSS program coordinators, NSS officers of our university, Dr. Santosh Matthew and Dr. Madhu Devaya, all my faculty colleagues, Professor Nalini, Professor Sakin Sultana, Professor Devan, Dr. Shankar Narayanan, Dr. Iftikhar Alam, all our research scholars, MSW students, and NSS and NCC volunteers of our university, and all other invitees and guests present here. Once again, my warm welcome to you all for this very important program. Thank you all. Thank you.
Thank you so much for your warm welcome, sir. Now I request Professor K. Anbu to honor the Vice Chancellor, Professor K. Taranikarise, with a show. Continuing with our event, I would now like to invite Dr. Gurminder Kaur, Nodal Officer and Head, School of Law, Pondicherry University, to enlighten the gathering on the history and need for these new criminal laws in the criminal justice system of India.
A very good morning to everyone. Honorable Vice Chancellor Sir, Professor Taranikarise, respected Professor Anbu, Head, Department of Social Work, Dr. S. Vijayan, Senior Assistant Professor in Ambedkar Law College, Pondicherry, all of my senior colleagues from the Department of Social Work, all the members of NSS Pondicherry University Unit, all the members of NCC Pondicherry Unit, all the NSS volunteers here, all the NCC cadets present here, and all the students and scholars of social work studies. As you all have been apprised by our young and robust lady who is the master of ceremony today, and also with the inputs of Professor Anbu about the relevance of the new criminal laws. So I have been appointed as a nodal officer to carry out awareness activities and outreach programs to spread awareness about these three new laws. And first of all, I would like to inform you that this initiative is being carried out under the directions of Ministry of Home Affairs, Government of India, through the Ministry of Education, Government of India. And as a first universal step, the Bureau of Police Research Department, under the aegis of MHA, had prepared very simple yet very, very effective posters for disseminating information about the new laws. The primary task was to bust various myths that were surfacing since the time the three bills had been introduced last year. So, in order to carry out that initiative, the School of Law has hosted two exhibitions to spread awareness about them. The first exhibition was conducted in association with Internal Quality Assurance Cell and the Directorate of Distance Education from 18th to 22nd of March 2024 in the DDE premises. That is also the place where the School of Law is functioning from. And thereafter, the School of Law hosted an extensive exhibition for 2 days, wherein the Inspector General of Police, Pondicherry, had presided over as the chief guest. That was done in association with the Central Library in the month of May 2024. Pursuing further, this is in compliance of the directive to involve NSS units and NSS volunteers, to train them first, and secondly to utilize their understanding to have maximum community awareness and outreach activities. With that understanding, this is the first session in which we have invited this very, how can I say, very quiet yet an outstandingly performing well person from the field of criminal laws in the Tamil Nadu circles, so far criminal law and human rights are concerned. Rather, sir and even myself, we had been involved in various stages of sharing inputs where academia was involved when the bills were under process. So I identified him as one of the very relevant people to come here and share in an encapsulated manner some training guidelines to you people. So the background of today's activity is largely in compliance of the directives of the Government of India, but most importantly for all of you to have awareness about a few things that are upgraded now, that will be dealing with you as citizens of India on a day-to-day basis. Similarly, this information and knowledge can be carried forward when we conduct various community outreach programs, preferably in the months of July and August within this year. So with this, I request the program to be continued further, and please pay attention, and towards the end we will also have a question answer round for 10 to 15 minutes. If you would have any doubts regarding whatever sir would be informing you about, please feel free to clarify. Thank you.
Thank you very much for your informative and insightful words, ma'am. Now, it's my distinct pleasure and honor to invite Professor K. Tharunikarasil, Vice Chancellor in charge of Pondicherry University, who has been a beacon of inspiration and steering our institution towards a bright and promising future, to deliver the presidential address.
Good morning everyone present here. Respected Head Department of Social Work, Professor K. Anbu, and this today's special address speaker, Dr. S. Vijayan, Assistant Professor of Dr. Ambedkar Government Law College, Pondicherry, and the Nodal Officer and the Head of School of Department of Law, Dr. Gurminder Kaur. And I could see there are many faculty members. Dr. Sahin is there, then NSS coordinator Satish Kumar is there, and Professor Devan, Professor Nalini, all other coordinators, organizing committee members, Dr. Shankar Narayan, and then Dr. Santosh Matthew, Dr. Madhu Devaya, and all the research scholars, students, NSS volunteers, NCC officer. Good morning, everyone. And this is very important function to familiarize ourselves with the new criminal laws. I think we have a special address, Dr. S. Vijayan, who is going to tell more about this. And also, I have been part of all these three functions, awareness campaign by School of Law. So this is mostly related to NCC and NSS coordinators. So how many of you from the School of Law background? Can you raise your hand? Okay. I just want to know, there is a chance that law students also may be NSS and NCC coordinators, correct? So that's why I want to know. So you may be wondering, so we are not related to law and we are not related to even criminal laws, and why these people are calling us, and why we have to know about these criminal laws. So definitely you are all part of social work and NSS, NCC, where your agenda is not fixed. So you have to have the idea about this. That is the reason they have invited you. But when it comes to the revision of any laws, but how many of you think that when we change the law, our life can be changed, or day-to-day life can be changed? Because I felt, most of us feel that whatever changes in the government, whatever changes in the law, it is not going to change our life. Do you think that way, or do you think definitely this law will change our life? How many of you think that the law will not have any effect? Whatever the law it is in the court, how it is going to affect us? That is the mindset of every human being in our India, because our population is huge, 1.4 billion, and the simple changes in the law is going to change our life. That is the mindset of any human, any Indian. But please understand, the Indian Penal Code, that is our Constitution, is only 75. We got the independence only 75 years before. But when it comes to the democracy, this is very young. 75 years is very young, the kind of population we have, and the kind of complexity in India also. So we don't have a same type of culture, we don't have same religion, same food habits. Every 100 kilometers, everything changes. To have a common constitution, it is not easy. We have been surviving this, and any democracy, 75 years is very less period. I understand the young generation is not happy with the kind of things around going on in around you. It is true. It is not only India, every country, the youngsters' expectation is very high. That should be also. Otherwise, changes will not come. Changes for the good will not come. That should be there. And how to change this? How to change this, whatever the way you want to change the country. So there is a time. There is a time for this. 75 years is very short period for any democracy. There are a lot of things to be done for any democratic country. Even the oldest democracy in the world, that is also facing lot of challenges. and more than 100 years, 200 years old democracies also, they are facing lot of challenges when time comes. So definitely we have lot of changes, and we have to change lot things to really have a democracy. I know there are countries, even not only electoral 5 years, after 5 years we are selecting our representative. That is the biggest democracy we have now. Between these 5 years, our role is very less. That's why our frustration also more. But there are many things we can do between these 5 years also, if really we want to hear from our people. Because the reason we don't want to have your view about, don't want to hear your changes for the democracy in between these 5 years is the two things. One is our population is very high, and the second thing is, you should understand this, we are all not matured enough to change small things in our country. Even our voting system also, how many of us is honestly voting for a particular person without having any prejudices? This is a still question mark with us. Just think about this. How many of us, forget about younger generation, our adult generation also, how many of us we are voting honestly without having any prejudices? Caste, religion, region, money, all those things, relatives. So when it comes to country, we have to live. I am not telling that we should not have any prejudices, but when it comes to the country, we have to think about country only. And that is the maturity we have to have. When we reach that maturity, definitely the changes will come. Because why I am telling this means, there are some countries where they can, in between also they can go for voting for any small changes, even inside the village or inside the state. But we don't have that system now. But we can bring these changes, provided you have the maturity enough to vote this, and our large population also, how to cater this. These are the challenges we have. That is why we are slowly growing into this democratic system, and in this angle only the changes are bringing here in this. So you can see these rules, this law is one is in the replacing of Indian Penal Code 1860. You can think, 1860, this colonial rule, still we are utilizing. We are not able to change. We don't have a time to change also. And even the Code of Criminal Procedure 1898, we got the independence, we are thinking that everything is changed from there. No, it is not so. Even the Indian Evidence Act 1872, we are still utilizing this. Only these three we are now replacing with the new criminal laws. So you can think of how many things we have to change. We really bring the changes in the society, because if we want to do the changes, only Parliament can do. So you can see how our Parliament is being done, and government also is flooded with so many issues, and if they really want to change anything, so they should be allowed also to run. So these are the problems. You should understand that the country is going through the changes for good reasons, and it needs time. For a democracy, we need time to change. 75 years is very young. You all should be very positive about this, and when you have a positive feeling, then only that patriotism comes, and then only you work for the country. So this is the, I thought I will share with you the importance of the democracy and the importance of changes in the law. Please understand that when you go through these three laws, you will understand how the simple changes in the law will change our life, because these are all the criminal laws. Unless otherwise we have gone through this law, or somebody affected in our family, how this criminal law will change their life, you can only understand. So that is why, so you can read about these three laws and give awareness to whoever you encounter, whoever you meeting them, whenever they affected in these things. Especially the women and children, they are now generally we are applying the same type of rule for them also. Now they call it as BNS, that is Bharatiya Nyaya Sanhita, BNS. This gives protection for women and children, and also harsher punishments. So this will also be very useful. If you go through this, you will understand. And I think our special address speaker, Dr. S. Vijayan, will give all those details. This is the third event we are arranging this, and my only request to you all is read about this. Don't keep this data with you. Please give the information to others. This will be very useful for others. That is your role. You are all ambassadors for this. Please take down these notes, whatever he gives, and tell everyone about this, so that when they face these issues, it will be very useful for them. So with this, I thank the organizers for inviting me this awareness campaign, and thank all the faculty members and the special speaker and the NSS coordinator and then NCC coordinator and Department of Social Work, Department of Law, all these faculty members, students, registered scholars, for arranging this function and taking part. That is very important, taking part of this awareness program. And thank you, one and all.
Thank you for your insightful address, sir. Your words have truly set the tone of our event and have provided us with a clear vision and motivation as we move forward. With that, we move on to the next segment of our event. Our speaker today is an eminent person in the field of law with 25 years of experience as a professor, and he has also published several research papers and has been a part of various conferences and symposiums. It is my great pleasure to introduce Dr. S. Vijayan, Assistant Professor, Dr. Ambedkar Government Law College, Pondicherry, to share his expertise on the latest trends and developments in criminal law in India, shedding light on recent legislative changes, significant court rulings, and emerging issues that are shaping the future of India's legal landscape. Please join me in welcoming Dr. S. Vijayan for his special address on criminal laws in India. Let's give him a warm round of applause.
I just wanted to start from basics. Then we will slowly move into what are all the new laws. We will just go on to see what are all the changes or what have been newly brought in. Okay, so that will be the idea behind the whole thing. I think it will be for around 45 to 50 minutes, and we will have 10 minutes of interaction of whatever doubts you may have regarding this or anything related, we may discuss. This is what we are here for, right? Crime. See, people say crime is something which is endemic in a society. Whatever kind of a society you may be in, crime will always be there. Crime will always be there. There are authors who have said, even in a society which is filled with people with angelic qualities, still there will be crime because their definitions may change, but there will be still activities which they will deem as crimes. So it is there. There are a few definitions, and I am not going to read those definitions. I am only interested in the third definition. What would be called as a crime? If possible, because it's a general terminology, right? What would be a crime, or what is a crime as far as your knowledge goes? Or what acts are made criminal, or what acts are defined as crimes? Can anyone tell me just? What acts would be made as crimes? Acts which are harmful to the society, acts which are harmful to the general public at large, acts which are punishable by the state, acts which could interfere with the normal functioning of government functionaries, state functions, and acts which could endanger the state as such, right? Then there is a third definition that is there. The third definition, it simply says any act which is generally considered to be harmful to the society, right? Now it could be harmful to the society as such, we may know, or which is considered as harmful to that group in a society which has the power to exercise its influence on the society as such, and they will make it as a crime. You may ask, what is the difference? Normally in a democracy we say, or in a place we say, the majority rules, or whoever, what the most of the people consider as something which is illegal, which we made as illegal, right? The thing is that when everybody agrees, or when most of the people agree that something should be made as a crime, we will make it as a crime, right? But the third definition says it may not be the case all the time. It says that even if you may be of what do you call us? I will not use terms which may be inferior. I will just say you may not be of numbers to influence the common thinking, but still, if you have the influence, or if you have the capacity to influence the people in power, you can still have laws that will be in your favor, or you can still make acts criminal if you feel that that is going to be either affecting the society or affecting your beliefs. All those things are there, right? So that is what it is, that is what crime is, and these are all the people. This is what the criminal justice system is, or how the criminal justice system aims to work. Criminal justice system aims at, again, prevention, detection, prosecution, adjudication, correction, restitution, right? I don't know, how many of you have gone through CRPC? Maybe some of you know what CRPC is, right? CRPC has two parts, and the magistrates they have, there are different executive magistrates and judicial magistrates, right? Executive magistrates are basically the revenue officials, the collectors, the SDMs, all those people are the executive magistrates, and the judicial magistrates are the one that you see in the court, wearing the robes, gown, whatever it is. Those are the people who are supposed to dispense justice, right? And these executive magistrates are the people who are involved in the first part, prevention. Along with the police, these executive magistrates are the people who will be actually on the ground maintaining law and order. Their duty starts, or their duty is to prevent law and order deterioration, to maintain law and order, to prevent the crime and other things, right? Their work will be till a crime happens. Once a crime happens, the police, again, executive magistrate's role is very, very limited, and executive magistrate will hand over the baton to the judicial magistrate, right? So that is how it is. So a criminal justice system wants to prevent crime first. Then if a crime happens, they go for investigation, detection. They want to find out who has committed the crime, what has gone wrong, and what is the problem, or what had happened. That is what they want to find out. Then there comes a prosecution, right? You may ask, sir, police, PP are all one people, you may ask, but still they are two different entities doing two different jobs, right? We'll just come back to them. We'll just come back to them in the later parts, right? Then comes our once your prosecution is over, you have adjudication. You tell me what a judge does in a criminal court. Again, I will just put the two options. One is in a criminal trial, what is the role of a judge? What does a judge do? I believe, is it his duty to say who committed the crime? Is it a duty of a judge presiding over a criminal trial to say who committed the crime, or to find out who committed the crime? It should be, right? No, that is not the duty of a judge proceeding over a criminal trial to find out who committed the crime. The duty of a judge would be indeed to find out whether the accused person who is standing before him has committed the crime or not. Right? When somebody is brought before a judge accused of a crime, the judge's duty is to find out whether this person has committed the crime or not, whether this person could be punished for the offense he is being charged with. And it is not the duty of a judge to say who committed the crime. Right? The judge did not say he did not commit, it was him. That is not his duty. The prosecution will also try to find out or try to prove that he is the one who is actually guilty, he is the one who has committed the crime, and these are all the evidences that we have, and this person should be punished for the crime that is being charged with. So, a criminal trial adjudication is not to find out who committed the crime. The purpose of a criminal trial adjudication is to find out whether the accused person who is standing in the, who is charged with the offence had indeed committed the crime or not. Then comes correction. Correction is basically, I won't use the word punishment, they use the word correction these days. So, correction would be, we have the jail there and we have other entities, other ways of correcting people or bringing people back to society, and it aims at rehabilitation. It aims at rehabilitation. And the last one I have put it in red because that is something which the new law wants to achieve. That is something which is there, or which is there in some form or other. Even in the 1898 CRPC we had restitution provisions. Even in the 1973 CRPC we had restitution provisions, but still they were not used to the satisfaction of the people who had actually suffered the crime. The victims have not been able to actually get the fruit of restitution. Right? And again, you may ask why, sir? Because when the British or the common law system works in such a way that the criminal law and the civil law are kept separate. Criminal law and the civil law are kept separate. Criminal courts and civil courts are kept separate. If somebody commits a crime, even though you are the person who is affected by a crime, but still the criminal laws deem the society as the victim. Right? The state will take care of the prosecution, the state will take care of the investigation, prosecution, punishment, correction, everything will be done by the state. For the harm that you had suffered, again you have to go to the civil court, file a case against the accused person, you have to get a claim compensation under the law of torts or whatever the civic law, common law remedy that you have, and you have to prosecute the person individually. Right? So, the common law system had broken up the legal setup. Criminal law is kept separate, civil law is kept separate. So, the victim's role in a criminal trial or in the criminal justice process is actually very, very minimal. That is why the restitution part was not given so much importance, because they thought that if you are a victim, you will again go back to the court of law and you will get a compensation. You may ask, sir, why did it not work? Again, have you ever heard of any victim of a crime filing a case against the convict getting a compensation? Have you heard? At least, how many of them know actually we can actually get compensation from these people? People who have committed the crime. Maybe very few. No, but every one of you would have heard about one crime for which this is done at a very large scale. There is one crime for which this is done at a very large scale. That is the motor accidents. If somebody is a victim of a motor accident, somebody dies, somebody gets a grievous injury, somebody gets an injury in a motor accident, there will be a criminal case going on separately. If somebody dies, it will be a 304A case where somebody will be prosecuted for the death that they have caused. Right? At the same time, there is some motor accidents claims tribunal where you will go, you will file a separate case, you will ask for compensation from the person who had caused the accident. The person cannot say, I have already been prosecuted in a criminal case, I have been asked to go for 1 year imprisonment and pay a fine of 10,000, 20,000. You cannot file a separate case against me because there are two different rights. Criminal law is different, civil law is different. As far as the criminal law goes, the society is the victim, the state is the victim, the state will take care of the prosecution. As far as the civil law or the tortious law is concerned, the victim has to go on and get a compensation. So, restitution for a criminal act has always been a distant dream except for this motor accidents claim. You may ask why. You may ask why. Because again, though it is going to be a criminal law, being it as an introductory lecture, will just slightly deviate. Because if you go to a civil court, you have to go with a advocate. The procedures they have there are like cob's web. You may not be able to find the starting point and the ending point of the procedures that they have. Even advocates with 10, 20, 30 years of experience may not be able to say that they know every procedure that is there in a civil court or before a civil trial. So, civil court is so cumbersome, you will not be able to go in without an advocate, and getting a good advocate is also something that you have to be, it's like flipping a coin. That's what you will get. One, it is expensive. If you're going to ask 10 lakh rupees, you have to pay something in the 10%, that is 7.5% of the compensation amount you have to pay as a court fee. If you're going to ask for a crore compensation, then you have to pay 7.5 lakhs to the court of law for the court to take your case. Right? If somebody dies, somebody is at 30, 35 years, working at a MNC, earning 2.5 lakhs per month, he dies means at least 1 crore compensation should be optimal. If that person has to go to a civil court and get compensation, he has to, or his representatives have to pay 7.5 lakhs. And if the person who caused the death happens to be someone who doesn't have any property or who doesn't have any means, who doesn't have any income, then even if you conduct a case, even if there is a judgment given in a favor to pay 1 crore rupees, you will not be able to realize. That person will simply say no means. What do you mean no means? That means whatever you have said, whatever liability that may have, I have no means to pay the amount, and that judgment cannot be enforced against them. Right? But how this motor accidents claims tribunal was able to be successful was because the amount will be paid by the insurance company. So at the end of a trial, you can be sure, rest assured that the amount will come. Whatever the judgment given by the court of law, the amount would be paid. And you don't have to pay the court fee upfront. You don't have to pay the court fee upfront. In a tribunal, what you will do is, you will just simply say, we are filing the case, depending upon the award, we will pay the court fee. If you ask for 1 crore, they only give you 20 lakhs. What will you pay? You will only pay court fee for the 20 lakhs award that they have got. Simple. Right? And again, the process is not also so cumbersome because they don't follow the CPC. They only follow the justice, equity and good conscience they follow. Right? So, that was something that made these things possible. Other than this, tortious law is something which is not yet picked up. Even though it may be 200 years old, it has not yet picked up and nobody follows. So, restitution happens to be a distant dream, and this new law wants to rectify it. They want to bring in restitution as a concept where a victim would be able to actually get some compensation from the criminal court itself. And though that would blur the difference between civil and criminal law, but still something has to be done. And these are the players. These are the players. In a criminal justice system, these are the people who are there. When I put the police, it includes all the investigating agency. Whatever name, whatever form or whatever things. When I simply put police, it includes all, it includes all prosecuting agencies. Then we also have the prosecution and the defense. And we have the judiciary, we have the correctional officers, and we also have the victim. Again, I put in the red because we will see why, right? Because police we know, we don't have to talk about the police. I hope everybody will know. I don't have to talk to you about the police, but still. Prosecution. Prosecution is very important because the public prosecutor in India has enormous powers when it comes to a criminal trial. They are the people who actually present the case before a court of law. Whatever they think or however they present or the way they present decides the outcome of the trial. Somebody may really be guilty, somebody may really have committed a crime. If the prosecutor is not competent, or if a prosecutor really wants to sway the judgment in a different line, a prosecutor can do. The prosecutor can indeed do that. So that is possible. Again, defense counsel is there. People representing the accused person will be the defense counsel. Then we have the judiciary. Judiciary is something that is supposed to be an independent body deciding upon the outcome of the case based upon the evidence given by both the prosecution and the evidence presented by the prosecution and the defense. Then comes the correctional officers. Those are the people to whom, if somebody is found guilty, they will be sent to them for correcting. Then victim. CRPC, the original CRPC is again the comprehensive CRPC that for the whole India came in there 1898. It was replaced during 1973, right? But a definition for the term victim was not there or was not coined till 2008. Only in the year 2008 a definition for the term victim was coined. Only in the Criminal Law Amendment 2008 the definition for a term victim was coined and victim was added because they wanted to add a criminal injuries compensation scheme into the law. Again, people may ask, sir, how can a law which is 100 years old or 150 years old can still survive? 1860 Act, 1872 Act. Again, though it is 1973, again it is also close to 50 years. How can these laws survive? Because laws did not remain static, right? There had been countless amendments. At every turn, wherever something was happening, wherever a judge found that there was something missing, wherever NGO or a public body found that the law needs to be changed, wherever the legislatures or the parliamentarians felt that there was a need to change the laws were always being changed. Whenever there was a technological improvement, the laws were suitably amended to cater to the needs. And again, it remained piecemeal. And what the new laws are going to do is they have arranged it or put together, packaged it in such a way that really works. Then, these are all the laws that we have as of today. Up to 30th of June, these are all the laws that we have that work on the criminal justice system. The IPC, the Evidence Act, the CRPC, the Indian Police Act and the Indian Prisons Act. You may ask, sir, there are 5 laws. But the government is only changing 3. Basically, the reason is that this police and the prison morely come under the state ambit, so the central government does not interfere. Right? They have given a model police code and the modern prison code also is there, and it is for the states to implement them. So that has also been suitably amended and upgraded, but still, as it is not something which comes under the ambit of a union list, so they have they have given the responsibility to the states to implement those model codes. Right? That is there. So, Indian Penal Code is there, 1860. Indian Evidence Act is there, 1872. And the Criminal Procedure Code is there, 1973. These are all the acts that we still have. People were hoping, I think again, yesterday's results have come. People are hoping that the implementation will be pushed back. I have met policemen, I have met prosecutors, I have met judges. They were all thinking that let's see what happens. If there is any change, the implementation of the law will be pushed back. But as the results have come, now everybody is so sure that the laws will be changed by 1st of August. 1st of August, these laws are going to, 1st of July, these laws are going to come. So we have hardly 25 days to get ourselves acquainted. And there are trainings going on. It has been going on for a long time, but now people will be going on a war foot to make sure that they are ready when these laws hit them. More importantly, the police and the judiciary. Police and the judiciary are the people who are going to be hit the hardest, because whatever cases they have filed till now, they have to go on with the old laws. And whatever cases they have filed after July, they have to go with the new laws. And it is going to be a head spinner for all these people at least for another 2-3 years. Again, though it is being replaced, IPC will be there in the judiciary for at least another 10-15 years. Because any appeal that goes all the way up to the Supreme Court will take 15 years. It will not be decided before that. So, these laws will be with us. That's why we are in a dilemma. Dilemma in a sense, we are changing our syllabus. Madam knows, we are changing our syllabus to include the new laws. If you teach them the new laws, and a student who passes out even 3 years from now, he will still be handling cases which were filed under the old laws. And he should also know that. So, we have to give them a comparative view at least for another 3-4 years. That is what we have to do. So, that is what it is. Then, these are all the people who are there. And next one. These were all the objectives and reasons given by the government for changing the new law. And what they did was, yes, a minute, it is taking its own time. To make the law relevant to the contemporary, make it modern, to make the law provide just speedy justice to the common people, and to make the legal system citizen-centric and secure life and liberty, all those things, and streamline the offences and penalties. So that is what the stated objectives are. Right? That's where the stated objectives are, right? But we could have gone even more, right? One more, right? If these changes would have been there, it would have been better. This is what we wanted. Amendment and replacing the Indian Police Act, because you have IPC of 1860 being replaced. Then a law which is only 1 year younger, 1861, the center could have done. There are ways and means for the center to do that. It is not like the center cannot do. Though there is a classification, center has its own ways. The Police Act should have also been amended. Right? Again, I am not talking politics, I am not talking this party, that party. I am just simply saying people in power, whoever is holding power, whether in a state, whichever state they may be, whichever party they belong to, they want to hold or they want to control the police. The Indian Police Act actually gives the control of the police to the politicians or the people in power, people who are actually ruling them. There are countries where these people are, there are countries where the police is as independent as the judiciary. Just we have a judiciary which is independent, the police are also independent. The prosecution is also independent. But in India, the police and the prosecution are at the hands of the people whoever is ruling. No party in India wants to change this. If they want to be in the ruling seat, whichever state they are going to rule, they want both the prosecution and the police under their control. Right? Prosecution is more important, because if you see, once a party, again in Andhra Pradesh the government is going to change, in Orissa the government is going to change, right? Tomorrow what will happen is all the public prosecutors in Andhra Pradesh and Orissa will resign. All the public prosecutors in every district of Andhra Pradesh and every district of Orissa will resign tomorrow. If not, they have done earlier, yesterday itself. Because all those appointments are political appointments appointed by the ruling party from their own party cadres. They have advocate wing. That advocate wing will be the people who will be posted as these public prosecutors. Right? So, any government, again any party, I am not saying this, that and all, any party who is in power, they want to keep the police and the prosecution in hand. Again, the new law also keeps the prosecution, public prosecutors only in the hands of the state. New law has not changed it. It still has the Bharatiya Nagarika Suraksha Sanghita also has the same provisions. Again, the prosecutors are still going to be in the hands of the people in power. That is going to be there. Police should have been, but let's see. These are all the things that should have been changed. Classification of offences, I will not go in depth into that, because it is more of again, I will not want to eat the time. Then sentencing policy, again, judges don't have a guideline. There is no guidelines given to judges as to how they should impose a sentence. Same offence, one judge may give a month prison, another judge may give 6 months prison, other judge may give 1 year imprisonment. The maximum punishment could be 3 years. Same offence, same situation, same thing, but still the judgment given may be different depending upon the temperament or the discretion of a judge. So we don't have a sentencing policy. That sentencing policy is not there in the new act also. That should have been there. Then expedite the process. That is there. Right? In the new law, what they have done is they have implemented limitation. They have given specific time. How long this should be done. What is the time given to a prosecution? What is the time given to a judge? Once he takes the cognizance, once the once the case is given to a sessions judge, how long is the time that they have to frame the charges and to start the trial? All those things are there. Witness protection. Witness protection. Again, even though you are not, most of you are only saying it in your, murmuring, mouthing, but still I will ask. What is the percentage of conviction in India? Leave alone those minor offences, traffic offences, minor offences, you leave alone those things. You tell me what would be the percentage of conviction in major crimes. I am talking about not the trial level. If we go from the trial to appeal, what would be the percentage of conviction? Something like 5 to 10%. Right? I will not go. Biggest reason for this is witnesses turning hostile. Witnesses turning hostile. Somebody who has lost a brother, who has lost a son, who has lost a husband or a wife, they would have been there when the crime took place. They would have been killed in their own presence. But when the case comes to the court of law after 2 years, 3 years, those people will take the stand and they will say that I did not see anything, it was dark, somebody killed my husband, I don't know whether it is them, I cannot identify these people, though accused person are there standing on the stage, I don't know whether they did it or not. Finished. Case is closed. Case is closed. You will be wondering why. Why should somebody who is so near, brother, husband, wife, son, main reason would be lack of protection. The husband is gone, the wife is there with 2-3 children. Somebody comes and say, if you go to the court of law and say anything against the accused person, next morning your house will not be there. You will not be there, your children will not be there, everybody will be killed in mass. What they will say? And we will give you some 50,000, 1 lakh rupees. Go and tell like this. Either money or coercion will make the people to flip-flop. So, witness protection is something that needs to be done, where we need to actually protect those people who are key witnesses in important trials. Again, whether witness protection is there? Yes. In Bharatiya Nagarika Suraksha Sanhita, there is a provision for creating a scheme. But that is left to the states to do. They have delegated the work to the individual states to come up with the victim protection scheme, so that these people could be protected from the thing. Again, to do that, we have to expedite the process. Two things go hand in hand. If a crime takes place today, the amount of anger that you have against the culprit and the social impact would be more. If it comes to trial within 6 months, everybody will be giving at least something which is close to the actual account. When the trial comes after 2 years, 3 years, everything would have slowed down. Every heat, whatever you have had, would have come down. And the possibility of people being manipulated is more. So, this expedition of process and the witness protection may be, again, we have to see how it works. Once it comes, if it really is implemented in a proper way, the percentage of conviction may be increasing. Right? This expedition of process and the victim protection will really increase the thing. Now, so you may ask, sir, we have not come to the... these are all the acts we have. Again, if we go into every provision, if you go into every little nook and cranny of these laws, this 1 hour will not be sufficient. I am only going to give you the highlights. I am only going to give you the highlights of what are these things. So, Bharatiya Nyaya Sanhita, that is the one that is replacing the Indian Penal Code, and the Bharatiya Nagarika Suraksha Sanhita is going to replace the CRPC, and the Bharatiya Sakshi Adhiniyam is going to replace the Indian Evidence Act. I have put it in the same order, but I will tell you, because at the end we may not may hurry up. So, the law which has gone through the least changes is the Bharatiya Sakshi Adhiniyam. Right? I will give you both the acts. I will give you bare acts of both the Bharatiya Sakshi Adhiniyam and the Indian Evidence Act. You can keep them side by side and you can read. They are almost the same word by word, except some provisions regarding the cyber crimes and the electronic evidence. Pretty much everything else is same. One may be section 10 here, section 7 there, section 11 here, section 10 there. Otherwise, it is exactly the same. Exactly the same. That has been the law which has been amended the most. What it had got is a makeover, a name change, and even the positioning of the sections have not been changed. Even the positioning of the sections have not been changed. Chapterization still remains the same. Again, wherever you had an amendment insertion, that were given original section name, sections, and that went as such. So, at the end it is there. I have given you some suggestions, but still, this is what it is. We will go to the main action. This is this. These are all the provisions that have been deleted. These are all the provisions that have been deleted. Now, normally we will say, there is one, again, you can see this, I will only go to one provision there. The definition for the term section is deleted. In IPC, you had a definition for section. It says every section in this law will be called as sections. One police official asked me, one policeman asked me, sir, now what will we call them? Should we call them section 11 or should we call them clause 11 or article 11? Indian Penal Code, there was a definition for the term section. It says that whatever sections are there, they will be called as sections. Now, that definition is removed. That definition is removed. And they were asking, sir, should we call as clause 1, clause 2, clause 3, or section 1, section 2, or article 1, article 2. But the general ruling is, if it is an act, it will always be sections. It is only redundant. We told them, sir, it is only redundant. It is only superlative. We don't have to have those things, but still it will be a section. If it is an act, it will be a section. So that is how it is. So we don't have to go through these things. Right. These things are there. They say sedition removed. We will see. All those things are there. I think if you go one by one, it will be there. I will go to next section. We will go. Right. 310 and 311. They were thugs and punishment for thug. Thug and punishment for thug. Those have been removed. The concept of thug has been removed. Originally, we had something called as the criminal tribes. Right. Originally, anybody who is associated with these groups, right, even though they may not have committed crimes of, they may not have been involved in actual crimes. If you are with a group which was designated as thugs, you may be designated a thug also, and you could also be punished, and that has been removed. And there is one more. I am particularly, I don't know what the law is going to do. 377 has been removed. 377 has been completely removed. Right? Supreme Court removed consensual intercourse against the order of nature. But Supreme Court did not remove non-consensual intercourse. But when the new law was drafted, they removed the whole provision. They removed the whole provision. Again, because these questions were asked when I went to the police training academy at Chennai, they were asking the same, sir, I was in prison for some time. And these kinds of non-consensual activities do take place. Earlier we were booking them under 377. Now what will we do? Even though Supreme Court was removed or outlawed or made as unconstitutional, if it is consensual, okay, that is consensual work is done, okay, you remove that, Supreme Court made it unconstitutional. But non-consensual was still kept in the books. But in the new law it has been removed. Maybe first amendment or the second amendment with the law would be including of this. Non-consensual would be included in the near future or should be included in the near future. Until then you have to go for hurt, grievous hurt, whatever you want to put, you put. Right? That is how it has to be. Then adultery is removed because it was outlawed by the Supreme Court of India. That is there. So you want me to go through each and every one, because that would be yes, no, please.
Second one, sir, attempt to commit suicide.
Attempt to commit suicide, right. attempt to commit suicide was is a peculiar provision. 94, the Supreme Court of India made it unconstitutional. Ratnam case, they made it unconstitutional. They said that a person is already in the in such a position where they want to take away their life. If somebody attempts to commit a life and survives, why do you want to punish those poor fellows? Right? And in 96, they had to reinstate the provision. In Gyan Gaon, they had to reinstitute the provision because that was a case under 306. This is 309, that was a case 306. Somebody asked, if somebody successfully completes suicide, the person is not punished. Somebody attempts to commit suicide, the person is not punished. It is not a crime because Supreme Court of India has outlawed it. Then how can abetting somebody to commit suicide could be a crime? Sarya? You get the point, right? If somebody tries to commit suicide and dies, again the person is dead. There is no way of prosecuting them. Somebody tries to commit suicide but survives, and we are not prosecuting them because that is not a crime, right? And there is one other provision which was still alive, that was 306, that is abetment to commit, where you instigate somebody or push somebody towards suicide. And in this case, people argued, said, successful completion of suicide is not punished. Attempting to do something is not made criminal because the Supreme Court has outlawed it. Then how can helping them be a crime? A person attempting something is not made punishable. Then if I help them or make them do it, how can that be a crime? Again, Supreme Court brought back 309. Right? It was there. It was still there. But what happened was, there is a law which talks about people with mental disabilities. In that law, what they have done is, they have specifically said if somebody attempts to commit suicide, they will be considered as person with unsound mind. Again, that provision will be coming in as a saving grace for them. If somebody who of unsound mind commits a crime, that person cannot be prosecuted or punished. Right? This act simply put it in black and white, saying that if somebody who attempts to commit a suicide would be considered by law as someone who is of unsound mind, so that person cannot be prosecuted. But there is one provision here that had been added. It says, if you attempt to commit suicide to prevent a public official from discharging his duty. Right? A Tahsildar comes, a PWD worker comes to demolish encroachment on a road. You would have seen pictures. People will pour kerosene on their head. We are going to set fire. If you destroy this house or a shop, we will set fire on ourselves. Right? You might have seen this. Or you will jump from the water tank. You will jump from somewhere. So that is actually an attempt to commit suicide to prevent a public official from performing their duty. Now that had been made into an individual offence. Again, that would also come into the same very law. Anybody who attempts to commit suicide should be treated as an person of unsound mind, and that person cannot be punished. So there will be a conflict between the Bharati Nyaya Sanghita and the person with mental disabilities. I don't know, I'm not giving you the exact name. So that is the act. So that it has to, there will be a conflict and they have to work together. How far? Because they will simply say it was not something which was, actually they were attempting, they were only threatening the people to prevent them from doing their duty, so they could be punished. So it is not there, but there is one provision, but it has been added afresh. What they have added is, if you prevent people, policeman is coming to arrest someone says, I will cut my hand, I will cut my neck, or I will pour kerosene, I will burn myself. Those things are made as an offence. Right? But general attempt to suicide has been removed. Okay. Anything else on this? If it goes section by section, it will be more.
So you can explain that in very short time, lurking house trespass at night. Because this was very helpful for evidence. In evidence, all witness and everything is retained, but from here they have deleted.
See, first for that, we have to tell them what is trespass, then house trespass, then lurking house trespass, then lurking house trespass at night. Very good. What is trespass? Trespass to property.
Unauthorized
unauthorized entry. Right? Again, trespass is there. What is house trespass? And house is basically where people live. That's all. It could be a house, it could be a tent, it could be a boat, it could whatever it may be, where people live. That could, though the term house is used, the definition is much broader. Definition is much. Sorry, sir.
IG arrested.
Hmm.
He was trespassing his own wife's house without her permission. Rajesh.
We know that Leela, that secretary, the last it is there, right? How to say? There are laws. We have all those. See, let me finish, right? See, that's house trespass. Then, lurking house trespass is where you are trespassing in such a way that you are trying to conceal your entry. You are trying to conceal your entry. In a sense, you are not going in the broad daylight. You are not going in such a way where people could see. You are going in such a way where your entry or trespass is, could not be found by others. Right? That too you are doing it at night. Right? Lurking house trespass could be in the day also. You are doing it at night. All those things are there. Right? And that is, those provisions are there. Those provisions are, now it has been removed. All those things there. House breaking at night is where you gain entry by breaking doing things. All those things have been removed. Those things are not there now. Again, this is what it is. Now earlier we had 26 chapters and 511 provisions. If you include amendments, it was 573. And now we only have something like 356 provisions and 19 chapters. This is what it is. And how to say? How this was achieved? Did we delete so many provisions? I know there are only a few people who have real access to IPC. See, what they have done is, they have clubbed a lot of sections together. They have clubbed a lot of sections together. In a sense, the definition clause of IPC was some 50 sections long. The definition clause of IPC was some 50 sections long. Every words were defined: death, goodwill, whatever, good faith, all those things. I am just giving, right? What they have done is they have put everything in one provision. So you have easily reduced by 40 sections have been reduced. Right? Earlier we had a separate section for offense and separate section for punishment. What they have done? They have put it together and say offense and punishment is put together. And there were even more provisions where they say offense, punishment, then there was some special offense for same kind, special offense. Again, a different variation. What they have done? They put everything together. So 4 different portions have been clubbed into one. Right? So these changes are again, reduction in number is basically by not real actual field change. It is only mixing the provisions here and there. Then have here also. Let's see. Then new offences are terrorism, snatching, mob lynching has been added, and new punishment is community service, and lunatic has been removed, and person with mental disability, the word has been used. Right? This is it. Right? See, what is community service? Though IPC has community service as a punishment, community service has not been defined in IPC. Sorry, BNS, still it is coming. Though there is a punishment added in BNS as community service, BNS does not have a definition for community service. The definition you have to go and find in the BNSS. Bharatiya Nagarika Suraksha Sanghita is where you will find a definition where as anybody who is forced to do a work as a part of a court order without pay. If a court orders you to do some social work or work without pay, that would be called as a part of a punishment, would be called as community service. Right? Earlier we had only 5 punishments: death, life, imprisonment, that would be either rigorous or simple. Then you had forfeiture of property. Then you had fine. Now we had a sixth punishment which says as community service. If you commit a petty offence, if you commit an offence, or if you are young, where sending you to jail would be more harmful than releasing you to the world, then you should not be let scot free. There must be some responsibility fixed on what you have done. So what they do is they go for community service. This had been in practice, though it has not been in the law books, it has been in practice. Right now it has been given statutory recognition. That's what I would say. The same thing is being widely used in many foreign countries. They will send them to parks, hospitals, they will send them to public areas where they have to involve in any cleaning activity. So many things they will make again, we have to see how it is. See, all these things are there in the books. Laws are there. Actual implementation and actually achieving the objectives of the law is still left in the hands of the people who are actually on the field implementing the whole thing. Those are the people that we have to be really looking into how it is being implemented, how it is going to come about. Only after July or even 5-6 months from there, we will be able to really find out how these laws have worked. Right? Mob lynching is there, snatching is there. Right? Snatching is a peculiar offense. Right? You have your bag next to you. Right? Or you have a mobile phone next to you. You are sitting. Somebody comes and takes your mobile phone away. Right? That would be theft. You have your mobile phone in your hand. Somebody takes it away from you without your consent by force and runs. That would be snatching. Did we really need a separate definition? I don't know. But still they found it necessary to have it and they have added it. They have added it. And again, this is one more thing. Normally, if a mobile phone is next to you, if somebody takes it away, that would be theft. If it is in your hand and somebody violently snatches it from you, the police will book them under robbery. Police will book them under robbery because you would have been put in fear of actual hurt. Then the theft would have been converted into robbery. But now by adding a section by snatching, what you have done is you have diminished the responsibility of the people who had actually done the offense. Right? You are wearing a gold chain and going on the road, somebody snatches the chain from your neck. Right? That is what is happening. Right? That should be snatching. They will be booked under robbery. Till now they will not be booked under theft, they will be booked under robbery, kollai. Because there is a real chance that you could be hurt. There fear in your mind that you will be hurt. But what it had done now is, now you have to book them under snatching. Then what would happen is, then there is a diminished responsibility. Though that the term I am using is different, but their responsibility is actually considerably reduced. Now we will see how it goes because it is the law. This is the law that we have in paper now. Real use will be seen only in the next forthcoming months, years. We will see. Right? What else? All those things are there. You can go next because we still. How long I can take, ma'am? Okay, I'll finish. Again, this is only one thing I will add. This is for BNS alone. BNS alone is though we have removed sedition. Sedition in a sense where you speak ill of a government. They say Rajdrog. What is a Rajdrog? Where you speak ill of your government. Now they have replaced it with Deshdrog, where you speak ill of your state, country. Right? So, sedition, again, these are the terms used by the government, and as I say, Rajdrog is replaced with Deshdrog. Again, this provision is even much more wider in scope and ambit, and the punishments are even more harsher. Right? So, again, don't run your mouth thinking that sedition is out. Sedition will still be coming back to you in a different name. Okay. So keep your comments moderated. That's what I will say. Right. Next. I'll just push through. Again, this has the most minimal changes. Next. This is one we have. Again, here also what they have done is the metropolitan area differentiation has been removed altogether. There are no, again this is, again the old one was, just go back, one. This is the Bharatiya Sakshi Adhiniyam, the one that is replacing the Indian Evidence Act. I have already told you, the one with the most limited number of changes, right? So I am just skipping it, right? Next. And this is what you have in the Bharatiya Nagarika Suraksha Sanghita, that is the new CRPC or the one replaced CRPC. The major change, that the most visible change that you are going to have now is, if you go to Chennai, you will see Metropolitan Magistrate 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. I believe they go up to 20, if I am right. Now, all those cadre of judges have been removed, and this cadre is now replaced, or it is removed as such. They will all be again called as judicial magistrates, as it is called in any other district. In Pondicherry, a person serving in Pondicherry as a judicial magistrate will be called as a JM. If they are transferred to Chennai, they will be called as Metropolitan Magistrate. Otherwise, the powers are not changed, the procedures are not changed, everything is the same. This is something that was, how to say, vestigial of the old law, so that has been removed, and this is what we have today. That is the one major change that you can see. And again, can you push 2 more slides? 1, 2. Right. These are all the new changes, major changes. As I have told you, witness protection has been added, but the state has to come out with their own schemes. And in case of criminal complaints by private parties, private complaint, I don't know how many of you have heard, if a police do not take your case, you can go to the magistrate and you can give a complaint directly, right? That is something. Earlier, the accused person may not be called. The magistrate will inquire you. If he finds there is a prima facie, he can start the case, he can book a case, or he can take the case as such. Now he has to call the other party before coming up. Again, legal aid for every trial and appeal. Earlier you would find legal aid was available only for in paper, or in law only for sessions trials. Now it is for all trials and all appeals, legal aid is available. People who are accused, who don't have, again, it is there. Practically it is being done by the legal service authorities, and now it is given more of a legal backing, or it is found in the CRPC itself. That's what I will say. Then you have e-summons, e-communications, all those things are there. All those things you can add. I will leave the PPT. I will ask madam to share with you so that you can have it. Then one more slide. Right. This is what it is. First part is for the DM. Whenever you find there is a public nuisance, a collector or SDM will issue an order to remove the nuisance. They have days, for specific days for that, and inquest should be in inquest reports 24 hours, completion investigation 90 days, free copies in 14 days. Deemed sanction. Now that is one. If you want to prosecute a public servant for something which they have done during the course of their work, you need a sanction for prosecution from the administrative head, right? The police will ask the sanction of prosecution, but now what BNNS has done is, if within 120 days, if they do not get a reply, then that would be considered as a deemed sanction. Police will ask for sanction. If you don't give the sanction within 120 days, then they can proceed with the case, because that will be considered as a deemed sanction. That is there. Then what else? Then I failed to add one more to this. Next, I believe we have finished, right? Handcuffing, data. I'll go for one more, because framing of charges will be in the court of law. FIR. If you go to a police station and if you report a crime, right, up until today, the police do not have a power to conduct a preliminary inquiry. The information that you give, if it discloses a commission of a cognizable offence, the police have to register an FIR. Right? The law is very clear. Law simply says, if your information discloses a commission of a cognizable offence, you have to register an FIR. There is no question of conducting a preliminary inquiry. Now, visarichite FIR kora. That's not the case. A police cannot say that I will conduct a preliminary inquiry, then I will go for FIR. That cannot be done. But now what this new law has done is, if you are reporting a crime, even though it is cognizable, if it is a punishment which carries less than 7 years imprisonment, the police are given the power to conduct a preliminary inquiry. They can take up to 14 days to complete the whole preliminary inquiry, and they have to go for registration of FIR, or they will say it is not coming under the ambit. Then you will go to the SP, then you will go to the court. Right? Till now, if you are a victim of a crime, or if you are aware that a crime has taken place, If you go and report to the police have to register the FIR. Right? Right? That is the law that is there. If you go to 154, if you see CRPC now, that is what you have now. If you won't read 173 of BNNSS, Bharatiya Nagarika Suraksha Sanhita 173, they have specifically said, and there is a loophole there also, I will speak it. They say 3 to 7 preliminary inquiry, but they are not talking about offences less than 3. Right? We don't know why, because they might have thought that less than 3 would be non-cognizable. But no, that is not the case. You have to go and look at the BNSS schedule to find out whether it is cognizable or non-cognizable. So now the police are given a power to conduct preliminary inquiry. So that is that. So if when you give up a complaint, make sure that you include those provisions or those words that will push the period of imprisonment to do something which is more than 7. So that they will register an FIR then and there. The words that if you use are something which is less than 7 years old, then they will not register an FIR then and there. They will say, they will make an entry in the GD and they will say, come back after some time, we will inquire, then we will register an FIR. Okay, I am stopping here.
It's my pleasure to give vote of thanks on this occasion of awareness campaign on criminal laws organized by NSS, NCC under Home Affairs Department, Government of India and the Department of Social Work. First of all, I would like to thank Professor K. Tharani Karasu, Vice Chancellor, Pondicherry University, for accepting our invitation and giving presidential address. On top of that, he stayed back for this function that motivates our faculty and students also to attend this function. Thank you, sir.